Welcome to our webinar today. This is going to be the third webinar in the 2020 Msha webinar series, so thank you for joining. I look forward to a good discussion today, and we will go ahead and get started. So today's webinar, you'll be joining for the ConMassiel Carey 2021 Msha webinar series is Msha Special Investigation Management. We'll be looking specifically at 105C and 110 investigations. For those of you who are new to joining, my name is Nick Scala. I am the chair of the National Msha Practice Group at ConMassiel Carey. I'm also a certified mine safety professional, where I represent mine operators and independent contractors around the country in all aspects of dealing with mine safety and health law, and specifically dealing with mine safety and health administration, whether that's managing investigations, whether serious accident, or special investigations and discrimination investigations like we'll talk about today, or just going through and providing counsel on compliance matters and contests before the Federal Mine Safety and Health Review Commission. We really do work with everyone from the beginning to the end of any kind of contest, and even when we're not doing contests, just to provide training support and compliance support as you go. So I look forward to our discussion today, and thank you for joining me. So as we talked about at the beginning, we're going to be looking at an overview of Msha special investigations. Specifically, as I said, we're going to focus on discrimination and interference claims under 105C of the Mine Act and special investigations into agents of management under Section 110 of the Mine Act. We'll also discuss some best practices and some strategies for responding to investigations in both instances. So hopefully, most of you have not had to go through any of these special investigations, but it is a relatively common aspect that we see when dealing with Msha, especially after an accident or a serious incident. And discrimination interference claims continue to be a pretty active area that grew and had a lot more action and activity going on in the Obama administration, but both we think are going to be areas where we could see a bit more activity in as we move further into the Biden administration. So with that, what are we talking about when we're talking about these 105C and 110? What does that mean? So 105C, just very, very high level, or 105 investigations are investigations into discrimination and or interference claims with minors or minors' rights. And those can be filed by three different classes of individuals that are all considered part of that protected class: the minors reps, and the applicants. These are also typically called whistleblower statutes. Most all federal regulatory bodies have one. OSHA has one. It's primarily under Section 11C. MSHA's is under 105. But that will be what we're talking about. And as we go through, it'll be handling these discrimination or interference claims that are brought against the company, much like any other complaint for a safety and health violation. So we'll talk about a bit more about what has to be proven as you go through that, what those mean, and how those can impact the company. In terms of 110 investigations, those are investigations into individual agents of management for civil and or criminal penalties. These again aren't entirely common, the civil side being much more common than criminal penalties coming down. But typically they are related to a 104D or an accident or some other kind of triggering event that brings into question whether or not there was a heightened state of knowledge or negligence by the agents of management at an operation in which led to that safety and health violation or that accident, whatever it might be. So as we go through, those are going to be the different types that we're talking about today. The Special Investigation Program, it's all managed and controlled by an arm of the Office of Assessments called the Technical Compliance and Investigation Division, TCID. Throughout the presentation today, when we reference TCID, that's who it is going to be. Now that is an arm of the National Office of Msha. That is not the same as when we talk about the Secretary or the Solicitor's Office, which is the legal side of these filings and this investigation process. And it's also not your regional or district. So this is at the national level. they're going to be the last level review before legal gets involved. A bit more closer to home, you have the district and the regional now levels involved with the regional admin and the district managers. When we go through special investigations, both of these parties are going to be involved a good bit in the process, whether they're approving or declining to move forward with an investigation or giving their recommendations on the findings. And then the real boots on the ground people are going to be the special investigators, the special investigator team, and then their direct supervisor is going to be the supervisory special investigator. So each district should have one of these. Obviously, sometimes the positions are vacant, but there should be one of those for each district. That person is going to be over all these investigations and will be that kind of first line of evaluation from the actual investigator who's handling the on the ground portions. So, that's a bit of a level review just within MSHA itself before we really start getting into the other side. So, with that though, we'll get kicked off and go right into the whistleblower section. So as I mentioned, section 105 really has two distinct elements with MSHA. You have discrimination, meaning discrimination or an adverse action taken against minors, applicants for employment as minors or minors reps. And that has to be the result of a protected activity. And we'll go through all these kind of terms as we go forward. And then the other one is interference. And interference is actually a bit of an active area at this point on the legal side, because there's questions as to what might be the key element that is, or that key test on how you prove interference. But there has been litigation going back and forth on this, but it's also much more nuanced, because there does not have to be necessarily an adverse action. It has to do with the minor feeling that something the company did or an individual agent of the company made them feel that they couldn't exercise their minor's right, whether that was accompanying MSHA on an inspection as a minor's rep, or filing a safety complaint, or calling MSHA to notify them of a safety complaint. If they felt like they couldn't do that for fear of adverse action, that is what interference is. So it's a much more nuanced kind of gray area that is not, you don't have the same kind of boxes to check as you do with discrimination claims. So we'll talk a bit more about that as we move forward today. So we're going to start off though looking at discriminations, and for the most part today, when I have up orange text that's italicized, it's going to be pulled directly from MSHA's Special Investigation Procedures Handbook. So that handbook is what MSHA gives to its special investigators, outlining kind of their procedures, their timeframes, their process, and also gives them guidance on what constitutes protected activity, what might be MSHA's position regarding a certain situation. So it's an invaluable resource, I think, if you're trying to understand how the investigators are approaching what they're doing when they're boots on the ground. So when they're at your facility and when they're looking at your specific case or your complaint, they're going to be going off of the training they received, and large part of that's going to come from this Investigation Procedures Handbook. So just like any of the MSHA handbook series, I think especially the ones that the inspectors read for or are trained on for how to do inspections, how to write citations, those are useful resources if you are trying to educate yourself on a specific aspect of the enforcement process with the agency. I will say that the MSHA handbooks have changed recently during the last administration. There was a significant calling and combining of coal and metal non-metal handbooks, as well as just really kind of a thinning out of what the agency felt was no longer relevant. They've streamlined them quite a bit. So if you're familiar with the old handbooks and haven't seen the new ones, they're probably going to be a lot smaller than you recall. I think some helpful information for operators is no longer isn't present, especially in the citation and order writing handbook. But nonetheless, they still are a good place to go to learn a bit more about how MSHA and their investigation teams are going through this process. So that aside, when we're looking at it, so what is a discrimination claim? It's so again, 105C says that minors, representatives of minors, and applicants are protected from retaliation for engaging in safety and health related activities, such as identifying hazards, asking for MSHA inspections, or refusing to engage in an unsafe act. These investigations are given priority over all other SI cases. So that just tells you a bit about MSHA's importance on these whistleblower cases, and we're also going to see this when we look at the time frames and the deadlines they have for completing them. But that's not an exhaustive list of what is going to be protected activities, but that is the basis of what we're looking at here with a discrimination claim. So we talked about it a bit, but how do you prove that a minor, or how does MSHA prove that a minor was discriminated against? So they have four elements that they need to look at and they need to prove, and these are going to be the goals of the investigator when they're on site to find out answers to these questions. So, is the complainant a member of a protected class? The protected class being minor, minors rep, or applicant minor. If they aren't a member of that class, they do not have standing under MSHA to file a discrimination claim. Complainant engaged in protected activity. Again, that we gave a brief example, but this is not a place for someone to claim that they were discriminated against for their religion or their sex or their race or anything of that nature. This is specific to protected activities covered by the Mine Act. There are other forums that are more appropriate and that will listen to complaints of discrimination based on those other classifications. But that is not the protected class, and that is not the protected activities or the protected class that we are looking at here for MSHA. Additionally, there has to be an adverse action suffered by the complainant. Now, this can be as cut and dry as termination or suspension without pay, or it can be much more nuanced, suspension with pay, changing to different job duties on site, things that can be seen by the complainant to have been punishment for something they did. So, that adverse action, it's an area where we can sometimes see MSHA going out and kind of making what you'd think is a pretty attenuated claim that an adverse action was suffered, or you get an instance where someone is claiming that, they were transferred to an older piece of equipment and that was an adverse action. I think obviously it depends on the situation for any one of these, but there can be a wide range of adverse actions that the complainants feel they're suffered. The next one, there must be a causal nexus. So what does that mean? That means there has to be a connection between that protected activity and the adverse action. That's, has to do with temporally as well as knowledge of the employer and so on. But we're going to go through each one of these a bit as well. So when we're looking at it, the protected classes, we've talked about it a few times now. So what does that mean? A minor is what we would imagine, right? Defined as a minor is anyone working in a coal or other mine under Section 3 of the Act. Okay, so that one's pretty straightforward. The representatives, that is any person or group or organization designated by two or more minors to represent their interests during health and safety enforcement processes. Okay, so if you're a union operation, you're probably much more familiar with representatives of minors than if you're not a union operation. But this is the individual or individuals who are chosen to represent the minors when MSHA is on site or in other matters having to deal with the labor force. For our purposes, dealing with MSHA and interacting with MSHA. As you can see, though, it's a pretty low bar to make that designation. You just have to be voted as a minors rep by two or more minors. So, that is sometimes an area where it can get into a bit of confusion, but it is a very low bar when you're going through it. A lot of times when MSHA comes out, one of the first questions the inspector or the special investigator is going to ask you is, where's the minors rep, or do you have a minors rep? So hopefully if you do have a minors rep or you don't, you know that answer, or whoever's going to meet with them is going to know that answer. And if you do, they're already, going to be prepared to come up and exercise their duties. But those persons can be discriminated against while performing their duties. And then they can seek the protections of the 105C as well. The last one is applicants. And, that's a bit of an interesting one, but applicants for employment in the mining industry can also file a discrimination claim with MSHA. Now, they don't have the same real opportunities. They don't get the access to temporary reinstatement like the other two do, which we'll talk about later on. And it's a bit of a more ambiguous process because there has to be some connection to something they did. And, in many instances, it's because of what they did at previous employment and, the question of whether or not they're being blacklisted. But applicants can also file discrimination claims. So that is what we're looking at when we're talking about the protected classes of individuals. In protected activities, we've talked about these, but making a complaint to MSHA is probably one of the most common, as well as participating in an MSHA inspection. If someone, and by that, I don't just mean the miners rep walking around, but if, a miner is talking to the inspector while they're on site, and then afterwards they feel like they've been disciplined for doing that. Complaining to the employer on workplace safety and health concerns, so that they feel that they are reporting issues or lack of training that they feel needs to be addressed, and then they're suspended for a reason that could be questionable, we'll say, and then they bring up this concern to MSHA. Participating in enforcement action is going to be again involving in that process of the investigation, or if they act as a minor witness in a litigation matter on behalf of MSHA against the company. Those are all things that are going to be protected activities. Again, refusing to work and refusing to work if you don't have that necessary or requisite training, or if they feel that they're not well trained enough. So these are all instances, though, where we see a lot of complaints. And this is an important aspect here is, one, obviously we can't take adverse action against individuals for making these complaints or participating in the actions we have listed on the screen. And this is not an exhaustive list, but this is some of the biggest or most frequently cited items. It's also important, this should outline how important it is that we need to have the workforce trust that when they bring a concern to us, we're going to look into it, we're going to appropriately respond. And for us, that we are going to, make sure we look at it and our people know that you're not to take any discipline against someone for that process. Now, obviously, I'm not telling everyone here that you can't ever discipline your employees, but you have to be careful why they're being disciplined. And all the management, everyone with disciplinary power needs to be aware of the potential repercussions of doing it when they feel like they just have someone who keeps maybe making a complaint about the same thing. If that's the case, but you've done an investigation, you've determined that it's not a safety hazard, that the appropriate training has been provided. I hope you're documenting everything you're doing there to look into that, and also hopefully sitting down and talking with the individual about why they continue to see that there's an issue. But certainly you have to be careful to discipline or take adverse action in that kind of context. So what is the adverse action? We talked about it, but some of the real straightforward ones, not promoting, not hiring, demotion, discharge, change in duties, poor evaluations can even be, in a sense, if that maybe leads to a failure to hire or a failure to promote. On the MSHA side, also the blacklisting. So, maybe someone leaves and they can't get a job because they're getting all kinds of negative reviews, or there's kind of a collaboration around the area that they won't be hired in. That can be seen as an adverse action. Making threats or intimidation has been found to be adverse actions, and even denial of overtime. If, again, it is linked to the person engaging in a protected activity. So, reduction in hours, suspension, layoff, or failure recall, those are all areas where it can seem innocent enough. It can seem straightforward enough. But if there is any question, or if there is an instance of recent note that the individual did make a complaint or work with Msha or anything of that nature, they can make the complaint. Msha will look into it. Msha is going to look into every one of these that comes in. That's an important note, both on the complaints, whether it's a complaint about safety and health condition or a complaint about discrimination. Msha will be looking into it. So we want to be careful about how we're treating the employees and how we're working with employees who are going to be making complaints. We'll talk about this as we move forward as well, but since we brought it up, if there is a health and safety complaint at the site, Msha comes out and says we were given an anonymous complaint that there was A, B, and C unsafe conditions at the site. A lot of times, the first thing that people want to do is find out who made that complaint. I urge you not to do that, because that is really just walking straight into a discrimination claim, because even if you go and you just yell at the person, or they can be seen as intimidation, that can be seen as a threat, and all of a sudden now they're already in contact with Msha about one complaint, and then they tell Msha that they were suspended, or they were told to go home early, or whatever it might be, and you're walking right into a discrimination complaint as well. So you need to be careful in that sense, that you don't really want to try and bird dog out who is that complainant, even when it's not a discrimination complaint, even when it's just a safety and health complaint about the site. So the next item on it, and this is an incredibly important one, is that there has to be this nexus, this operator knowledge with discrimination, that a protected activity occurred and then adverse action was taken as a result. That, as I mentioned, that isn't just, there also has to be some contemporaneous nature to it. So it can't be, oh, well, I made an investigation or a complaint to Msha 18 months ago, and, I was laid off today. That's obviously going to be a really big divide. There's going to have to be a lot of things that happened in the middle there to continue to prove that there's a connection between the two. But, if you make a complaint and a week later you're put on night shift and you make a complaint to Msha because that was a result, or you feel like it was a result of your complaint, that's pretty close time frame. So, the special investigator is going to go out. They're going to try and evaluate and find this information. They're going to be doing a lot of interviews. It's going to be interviews also with management. It's going to be interviews with co-workers, and then there'll also be, and this is more to remember, the complainant doing the interviews with Msha on the back end that you're not privy to. So in that, they will begin to find what they believe is either the direct evidence or their circumstantial evidence, but evidence that proves and establishes that nexus. And again, that the person who took the adverse action against the complainant, or a person who influenced that and directed that to happen, knew of or suspected that the complainant was engaged in protected activity. So that's an important element. It also applies when you don't know that maybe a complaint came in and you think it was a particular person, so you discipline them and it actually wasn't them. That can still be discrimination. That still is discrimination for them engaging in their protected activities. So those are the elements that EBSHA is going to be looking at that they're going to need to prove. Another very interesting and really strong tool that MSHA has at their disposal in these complaints, which is a bit unique. OSHA doesn't have temporary reinstatement, but it's this theory of temporary reinstatement, and that is that, especially when someone has lost their job, the complainant can request temporary reinstatement during the investigation and the subsequent litigation. What that means is that if it's found that there's a reasonable cause to believe discrimination may have occurred and the request is not frivolously brought, Those are very, very, very low bars from a legal standard. The federal, MSHA can move on behalf of that individual, and the solicitor's office will move on behalf of that individual to get them reinstated for the pendency of the investigation and the litigation. And that means that they either have to be brought back to do their job, which in most cases isn't what people want. So then in the instance that you don't want this person back on site, they have to be economically reinstated, meaning you have to bring them back to their pay and benefits from the time of their departure until this is all completed. So, this is a really strong tool. These cases, the investigations move pretty quickly, but the litigation itself can go for a very long time. And that's really where temporary reinstatement can be quite burdensome. So it kind of overshadows a risk with MSHA on the discrimination side that you don't have in a lot of other workplaces. This has to be filed by MSHA. It's not available for applicants, and it's not available if a minor, is bringing a claim themselves, meaning MSHA didn't take it up on their behalf, but they're filing it before the Federal Mine Safety and Health Review Commission. Those individuals aren't eligible for temporary reinstatement. But if MSHA is bringing a case forward, then the individual, if they have been terminated, can go and get that, or if they've lost some rate of pay or other benefit. So what are we looking at in time frames? We know that these take precedence over all other special investigations. So, I've been on 110 investigations where they've been paused and the investigators have gone and done a discrimination investigation and then picked back up because the timelines are much different. But essentially, the complainant has 60 days from the date of the adverse action to file a complaint with MSHA. There can be a little bit of wiggle room there, but they have to then explain why there was a delay and why it went beyond that 60 days. Once a complaint's filed, and this is, if we're looking at the screen right now, the blue box, this is a discrimination investigation. They have 15 days after the complaint's filed to initiate an investigation, 45 days to submit that report back to the national office at TCID, 60 days from the beginning, not additional 60 days, 60 days from the complaint being filed. There is TCID has to complete their review, and 90 days from the complaint being filed, the solicitor's office has to file a complaint with the Federal Mine Safety and Health Review Commission if they're going to do that. So, when we're looking at this, we're essentially 3 months from the date of the complaint. If MSHA is going to move forward by filing a case on behalf of this individual, it will be filed. Now, those deadlines can get extended, but MSHA, at least on the discrimination side, tries to stay true to them. The special investigation side, that's a bit different. Those can drag out a bit more, but on the discrimination, they try to stay close to these timeframes. Equally and important and much quicker is the application for temporary reinstatement. So on the day the complainant talks with the investigator for the first time, they have to explain temporary reinstatement. And if the complainant requests it, they have 7 days to notify TCID and the solicitor's office of the minor's request. 15 days from there, the district has to submit their findings to TCID and their recommendations. 20 days from that request, MSHA has to refer that to the solicitor or decline to do so. And 30 days afterwards, the solicitor has to file an application for temporary statement or decline to do so because they don't believe that there is substantial basis. So, we're talking a month after the complaint's made, applications can be going in for temporary reinstatement. So that is quick. Obviously, it's quite quick, but so these do move fast. And so that's another thing we need to keep in mind. If we ever do find ourselves in this discrimination, they move quickly in a discrimination claim or an interference claim for that matter. They move very quickly. So we need to have our procedures in place beforehand. We need to have some practices in place beforehand. We need to have individuals trained and know what we are doing when a complaint like this comes in, so we're ready to respond. So what is interference? I told you this was a bit more amorphous. It's a bit more gray area. You know, again, some language from the handbook, but the conduct reasonably can be viewed as tending to interfere with minors' exercise of a protected activity. Then it goes on to say the focus of the interference analysis is not whether the employer or person acted in good faith, but rather when their actions reasonably viewed from the perspective of members of the protected class, again, minors, applicant minors, minors reps, and under the totality of the circumstances, tended to interfere with the exercise of their rights. So did the company do something to make them feel like they couldn't exercise their rights? That's what an interference investigation is trying to find out. You know, did you put in a bonus system? And this was a case not that long ago that made it seem like there was a chilling effect on the individual's ability to report injuries, or put on emphasis on them not to miss work so they worked through injuries, or they didn't feel that they could go and walk with Msha as a minors rep because their crew might lose out on a production bonus. That was actually a case. Both of those questions came up in, and it was determined by the AOJ that was interfering with the minors' rights. So there does not have to be a protected activity that was exercised. There does not even have to be an adverse action taken against the complainant. What we do have, though, is Msha, you know, and Msha does not believe, according to one of the two legal tests out there, that needs to prove there was operator motive or intent to even interfere with the exercise of minors' rights, just that the minors felt that way. So again, a very amorphous gray area. I told you there was a couple different tests out there. That's because ALJs have been trying to move through and figure out how to handle these and how to evaluate these. And so they're trying to create legal tests. What we have now with the commission is two tests for interference. The Franks and Hoy test is the more popular by Msha. They had proposed this. It was adopted by an ALJ and several ALJs. The commission has not officially adopted a test. And in a couple instances where we thought we were going to get a final test that was going to have to be adhered to by the DC Circuit Court or other circuit courts, they did not give us that kind of clarification. So we still have these two tests floating around. Franks and Hoy is probably the more popular of the two for Msha and for the majority of the ALJs right now and the decisions we're seeing. But then we'll also talk about the Pepin test moving down. But this one essentially just says what we saw with the Msha guidance. The action can be reasonably viewed by the members of the protective class as tending to interfere with the exercise of the right, and the person, being the person who interfered, fails to justify that action with a legitimate and substantial reason whose importance outweighs the harm it caused to the exercise of protected rights. So again, in this instance, you don't even have knowledge of an adverse action or of a protected right taking place. It can be very much that the minors felt something acted in a way that had a chilling effect on them, and even if that was not the intent of the other side. The other one is the Pepin test. It incorporates much of the same elements, but they have a third point in the middle, and it says such actions were motivated by the exercise of protected rights, meaning there was an intent to try and stop those protected rights from being exercised. And they were trying to interfere with the process, as opposed to they did not have that intent, but that's how the minors felt. So the Pepin test is obviously the test that really the employer bar, the employers and the employer bar would like to see become that final one, because there is that other element that there has to be some intent there. Whereas the Franks and Hoy test is a bit more open to the interpretation of the workforce. So those are the ones that we're dealing with right now. They're both out there recently in a pretty big case. The judge just used both of them. In that instance, the judge found there was interference under both instances, but we don't have one that is favored. So where are we at in responding? Because that's really the important part. So if we talked about before, this is pretty straightforward, but if the worker is still employed, do not retaliate if there is a complaint that comes in or an investigation that comes in. We should start doing our own investigation very quickly. Determine, is it timely filed? That's your first bar. We want to start collecting our documents. We want to interview employees with any knowledge of it. We want to record our investigations and findings. Obviously, my recommendation is that's all done with an attorney and as part of the attorney's investigation under privilege, because that will help you, move through that process. But if you are going through and you're collecting documents or you're interviewing people and taking statements, and an attorney is not doing that or not working with you to complete that task, that is going to be available when Msha comes in and says, hey, I want to see any statements or any information you have regarding this investigation or any other investigation into a similar incident. So just be clear there that, with any accident investigation, they're essential. But if you're not taking precautions with them or not being careful with what information you're collecting, you could very well be giving the playbook to the other side. Additionally, you're going to want to prepare a position statement. When I handle these for clients, we prepare very detailed position statements that we provide to the investigator towards the end when all the interviews are done. And this is really, it's our case. It's our case in a sense that we are going to outline our version of the facts, what we think maybe is being misconstrued. We're going to outline our legal defenses, why they have not satisfied any of those criteria we were talking about before: protected class, adverse action, protected activity, causal nexus. And we go through each of those in a great bit of detail. So, those aren't required with Msha. You don't have to put a position statement. You can rest on the statements or the testimony or the interviews, but, I think that those are very helpful. They can be especially persuasive if they're, a legal document and they're written in such a way that it outlines very clearly to Msha a contrary case to what the complaint claims. We want, again, what are our goals there? We kind of talked about it, but we want to give them an easy to follow story. We can determine what other documents or what documents maybe were the most relevant of everything that was dumped with Msha's request, because they're going to have a pretty big document request in most instances. It does have the effect to say that we're taking this seriously, and we looked into this pretty detailed ourselves, and this is our position. It also gives us the ability to frame the allegation in what might be a much different light than Msha first heard it. Because of course, when they first hear these complaints, they're coming in, they're hearing nothing but the employee's point of view. And so when we go back through, we get the opportunity to see if there's a different story that we're hearing. Obviously, if the case is that the employee is telling the truth and there was a kind of discrimination or a discriminatory act, that's tough, because we have to figure that out. We have to, navigate how to move forward in that process when, there can be an admission or something of that nature. But in most cases, there's a disagreement of the facts or how something occurred, and this is an opportunity for us to review them. This is we're going to do a statement of facts, just give a bit of background on the business, but more importantly, on the applicable policies and procedures and the job and job duties of the complainant. A lot of times there's overstepping in what people say they were doing or had the authority to do when we're going through investigations compared to what their actual job duties are. So we want to know that. It's also helpful in those situations to have a job description. So, maybe that's something you have. Hopefully, if you don't, it might be something you want to start creating for each role in the facility. The legal analysis, this is really where we want to go and evaluate the legitimate reasons for our actions and also the lack of connection between our action and any kind of protected activity that the complainant is bringing up. And that therefore would lead to our conclusion that in most cases, and again, these are all dependent on facts, so it's not a one-size-fits-all, but that the employee's activity was not protected, or that the action that was taken was not adverse. If you're in that instance where you're trying to argue that action was not adverse, but it was taken related to a protected activity, that's a bit more difficult. So hopefully you're able to argue, and we're able to look at this and say there was no protected activity because of A, B, C, and D. We talked about it, but documents can be very helpful. These will allow you to hopefully show discipline records, evaluations if that's applicable, policies and procedures that maybe were violated. But as always, we want to be sure that we give what's relevant and not more, and relevant and responsive and not more. And we have to, because these are going to go into a file that are going to be very possibly handed directly to the complainant, or they will at least get copies of them in the final report or be asked to review them with the investigator. So you want to be careful about that. But nonetheless, that's going to be a big part of it. How do we prevent these? How do we move forward this? How do we get ourselves in a position to respond in the event that one happens? A lot of it is training. Our supervisors or direct reports, they need to know what retaliation is. They need to know how to manage the protected employees, or how to respond or not respond to protected activity being exercised by the workforce. They need to be very clear about what is the minor's rights. Okay, we have to be, this is kind of an intersection of Msha law and employment law, but it still does have to go back to those minor rights, because we're guided here and we're governed here by what is covered in the Mine Act. But your management should know how to respond to complaints, whether that is complaints made on discrimination or complaints just made about safety and health conditions. And we want to make sure that they know how to adequately and appropriately respond to those to make the workforce feel like they are being heard. And then we are taking them seriously, because a lot of times those people who are in the boots on the ground are going to know what the actual conditions are. We also want to, document a legitimate response to employee conduct. So are we keeping documented employment disciplinary records? Are we disciplining everyone equally? Do we have a system in place for how we discipline? Do we have a procedure in place or a policy? So we want to be clear with that. If we do have a situation where we see a complaint coming in, we want to make sure we have a written documentation of that. We want to detail our decision-making process so that we have a very clear outline of what was done and why. If we do employee interviews, we want to try and keep notes of that, and also not have individual one-on-one interviews. As employers, we would always want to have at least multiple people sitting in to verify a story, so we're not in a he said, she said situation at any point in time. And then we also want to, look at the findings and take appropriate action afterwards, whatever they may be. So, that's a quick overview of a very significant topic in discrimination claims. The other side of the special investigations is agent investigations. And there can be overlap between the two, but Section 110 gives Msha the opportunity and the authority to pursue civil penalties, so fines, and that is much more common, as we said earlier, or in rare cases, criminal penalties against agents of management. This applies to agents of corporations, so there is a bit of a carve out there. When you're dealing with a partnership or something like that, it doesn't necessarily apply. So, know what type of entity you are. If you're a small operation, you're probably, or you may be in a situation where that is not an option because you're in a partnership, and therefore Msha is not going forward with 110 cases against you. You have to be looking at people who knowingly orders, authorizes, or carries out a violation of a mandatory safety and health standard for civil action. If we're looking at criminally, then we're looking at willful behavior. When we look at willingly, it doesn't mean that there's bad faith. Again, this is taken from Msha, or evil purpose or criminal intent. Its meaning is that a person has reason to know that reasonable care would require them doing more. In terms of, it also has to be supported by a citation that MSHA has upheld. So by preponderance of the evidence, that is the burden of MSHA if we litigate a citation. So, if there is a 110 and you have an underlying citation, if you get that citation vacated, the 110s go away. Also, 110s typically have to do with high negligence or more on the underlying issuance. So if you're able to get the negligence down, oftentimes the 110s go away as well. So that is to say, if you are getting citations that are high negligence 104G orders, high negligence citations tied to a 107A, unwarrantable failures, you should think very critically about whether or not you're going to contest those or accept them, especially in an instance where there's maybe an accident or an injury or something of that nature, because those are all kind of your most typical groundwork for agent cases. And it can be difficult to fight the agent cases if you've already paid and accepted the underlying citation. So, I think if those citations come in, I'm looking at them very hard and probably going to contest them, without even considering the agent investigation. But when you bring that into consideration as well, you need to look at, well, do I need to contest these so that I can keep maybe that fight alive in the agent investigation? So something to consider there when we're going through and we're getting a serious citation, if we ever do. On the criminal action, it's obviously a much higher bar. You are then going to get into, the criminal process. It gets referred over to the Department of Justice. I will say that, in this case, it has to be failure to comply with a mandatory health or safety standard, and that is a willful failure, meaning it's done knowingly and purposely by a mine operator who, having free will and choice, either intentionally disobeys a standard or recklessly disregards its requirements. So a higher bar. There's also provisions under 110E and F that have to do with falsifying documents or lying to MSHA. And those are actually probably the most common ways that people get into criminal hot water with MSHA, is that they either during the course of an investigation are caught lying to MSHA, or they have falsified a record. And because that's pretty concrete evidence if they can show that they were changing dates or they were creating records after the fact. And that is one area where MSHA will pursue criminal charges. So, I think that's probably something that we all know we shouldn't be doing, either lying to MSHA with the intention to deceive them, or changing records with the intent to cover things up before they get access to them. Those are pretty straightforward things that are going to get us in hot water, and those are the most likely areas that we're going to get the criminal review. For the very vast majority, we're going to see these being civil investigations. So what's that mean? It means you're going to get a fine if MSHA has a positive finding when they get through this, but not to the company, to the individual agent of the company. Now, in a lot of cases, and it depends, companies I've worked with, a lot of times they make my services as counsel available to those supervisors. However, if there is a conflict there, that's not an option. So, they might have to go out and get another counsel to represent the individual during that instance. This is especially something you see if there's an accident and, there's any pointing of the fingers between the manager or the supervisor and the company as a whole or as a larger entity. But, you see them with unwarrantable failures. Back in the Obama administration, it felt like there wasn't a 104D issued that didn't have a agent investigation that followed it. We saw what felt like a pretty steep decline in those civil kind of agent investigations after 104Ds were issued under the Trump administration. But I have a feeling this is an area where we could see an uptick, and I've already dealt with more agent investigations in 2021 and late 2020 than during the last or the year or so prior. So I think that this is an area we're going to see a continued uptick in activity. It can also be initiated as the result of a complaint investigation with positive findings, especially again if we're looking at things with higher negligence following serious accidents, fatalities. I think that is pretty common. That still remains pretty common, depending on the underlying facts and management's involvement of it. Even after positive findings of 110 investigations, there can then be aging investigations in addition to what the company is dealing with on the discrimination side. And then also, at the request of MSHA inspectors or management, if they feel like they want a special investigation completed, they can make that request, as long as the underlying criteria are met. So, we're looking at a much longer time frame, as I mentioned earlier. It begins with the date of issuance or the date that MSHA had notice of the incident. They have 30 days for the regional administrator to initiate or decline doing an investigation from that date, 40 days from the date, 45 days to decide if they're going to move forward if there was a preliminary investigation, meaning a quicker one before that where they have a bit of time to look into it. After 60 days, a new case should be admitted where, again, that's where you're going to be getting into whether or not charges are going to be brought. The recommendations from districts should be to TCID 150 days out. So if you'll remember, the end of the time frame and deadlines for action in the discrimination was at 90 days and 30 days if temporary reinstatement is being requested. So we're at 150 days, almost 5 months, and the district just has to get recommendations over to TCID. Again, 220 days after that, we have to have the recommendations into the Office of Assessments for penalties to come out, and 240 days is the deadline for a criminal referral to the DOJ. Now, but these are all, as I mentioned before, deadlines that can get extended, and we've seen that a good bit where they get pushed out. So, be aware that these aren't hard deadlines. MSHA has a bit of leeway here to keep extending those as they need to. A lot of them finish up sooner, and this isn't, to say that everything's going to take, 220 days, but that is the time they give themselves without even getting into their ability to request extension. So a much more drawn out process it can be than a discrimination investigation that moves quite quickly. So what is MSHA? When they come on site, what are their goals? If there is a special investigation, well, their goal is to identify information linking management knowledge to the conditions prior to the incident or the issuance of the citation. That's their goal. And how are they going to do that? They're going to do that by requesting documentation, and they're going to do that by interviewing employees. And employee interviews are going to be the primary driver of special investigations usually. They will get that information, whether it's management or non-management employees, but they're going to look at that very closely. They will also talk with the inspectors to issue the underlying citations or investigators if it was an accident or injury investigation, and get that information from them as well. They'll also request their own documents. This can be a frustrating process, but it will very often will be the same documents that were requested previously by the initial inspector or the accident team. So, companies get frustrated by that, but these special investigators will very often request the same documents or a broader request. Now, MSHA does not have subpoena power. They don't have that authority like OSHA does, but they have very, very broad discovery request authority under Section 103H of the Mine Act, which essentially says they can demand whatever they want in order to complete their investigations. Companies have challenged this. It's typically an unsuccessful challenge. So what I tell people is that, you're usually going to have to turn over the documents that MSHA requests unless you can talk them down if they're not relevant, or if there's something about those documents that you really do not want to turn them over. You need to understand that to challenge that is going to be probably a protracted bit of litigation. And in the end, Msha may very well just be granted it by the court, given the broadness of 103H. So I'm not telling you hand over everything they want immediately, but you need to understand, if you're having a discussion about not wanting to turn over documents, that Msha will pursue them unless you can convince them that, that document isn't going to have what you want, or that document's not necessary, or that document's privileged because it was done with an attorney or done by an attorney, or anticipation of litigation or something like that. Those are the areas where you can really claim that you're not going to provide it under 103H, and then they would have to challenge the privilege, not just the scope of the request. There was a case a few years back, a Warrior Cole case, where they attempted to challenge whether or not Msha could request all the names and contact information for the minors at the initiation of the investigation. This is very common. It's pretty much the first thing they ask. And in that case, Warrior wanted to limit it to a specific work group, and Msha wanted the entire mine's worth. They challenged that, and it went to court, and they said give them the entire mine's worth. So now when Msha comes out, it's probably going to be the first thing you hear is that we want the contact information for all minors on site. And that will come into play in our next one. You should all just expect any required record that you're statutorily required to maintain by Msha is going to have to be provided. It's likely to be requested. It's, workplace exams for 12 months are often requested. Training, pre-shift examinations for mobile equipment. So know what you have to do, how long you have to keep those, because you don't have to keep pre-shift mobile equipment examinations for any duration of time after the defect's corrected. But if you have them, Msha may very well request them if they find that out. Production reports come into play, company safety and health policies and procedures, any investigations and statements. Again, why it's important and beneficial in times to work with counsel so that those accident investigations, those statements are taken by counsel and conducted by counsel and therefore privileged. Because a lot of times those are things that you want to do, you want to read, you want to get into having, a fluid discussion on it, but then Msha comes in a month or two later for a special investigation, and they immediately request it and turn it over. And you have to turn it over if it's not privileged. So things that you want to consider as you go through it. As I said, primary source is going to be the interviews though. And what we just told you guys about their ability to request contact information, it is not uncommon at all for these special investigators to reach out to minors at home, on cell phones, actually show up at their houses. We hear stories about that. So, you should be training this to everybody as part of their minors' rights, but all minors need to know, management or non-management, these apply to them, that they can voluntarily speak with Msha and you won't take any action against them because that's discrimination, as we just talked about in 105C. They can decline, though, to speak with Msha too. That's absolutely their right. They can speak with Msha alone, but they don't have to. Msha can't force them to speak alone. They can speak with Msha with any representative of their choosing present, anyone. Msha doesn't like it to be management, but if that person actually wants management in there and they weren't told you need to ask management to be in there, that's perfectly fine. They can write a statement for Msha, but they don't have to. And they can say no. They can sign a statement that Msha wrote down, or they can say no. Now, if I'm talking to you as an agent of management that I'm representing in this, I will tell you don't sign anything unless it is 100% accurate. Signing means that every T is crossed, every I is dotted. I worked one investigation and it was a fatality investigation, and we sat down and we had our foreman speak with Msha. And after we got done, Msha asked the foreman if he would sign his notebook to verify what was recorded. And we asked the investigator to read it to us so that we could make sure it was accurate. They're not court stenographers. They're not there for catching every word. So it's usually not going to be accurate. if you spend any time digging into Msha field notes or Msha interview notes, these guys aren't catching every word. So know that, because when you sign something, or when your employee signs something, Msha is going to hold them to what's in that. But getting back to that story, though, the investigator couldn't even read his own handwriting to tell us what he had written down. And so obviously we didn't sign it. Obviously the foreman didn't sign it because he didn't even know what he was signing. So, everyone should know those. Management, this applies to you. Non-management, it applies to them. You don't have to do any of these things. Msha can't coerce you. They can't tell you things like, well, you're going to speak to me one sooner or later, so you might as well be right now. No, they can't say that. These are things that we should cover with our workforce regularly, and cover with them if we're getting into an investigation, and not cover it in a way that makes them in any way think that you're trying to tell them to do something or not to do something, but to very clearly discuss it. A lot of times when we're getting ready for an investigation, or we think an investigation might be coming, a special investigation, when I'm working with a client, we'll write this all out and explaining and just put it in writing. And it will say these things on it, and everyone has the option to do what they want, but they know their options are there. So, that's something to consider if you're ever in a situation where you're going through an informal. What are some common pitfalls? Again, these are pretty straightforward, but they're things that people do when they get panicked. They're things what people do when they feel threatened. Don't attempt to influence an employee's statement. Don't threaten an employee. Don't tell them they can talk to Msha if they want, but they really shouldn't, because that'd be bad for the company. Obviously, those are going to cause all kinds of additional headaches beyond what you're dealing with a special investigation, because now we're looking at interference or discrimination claims like we talked about. Don't feel that you should and do not create a story or try to synthesize a story for everyone to adhere to, because that is not going to pass the smell test when Msha starts interviewing people and everyone says the exact same phrases and verbatim and things like that. Be cautious if you are going through an inspection or an accident investigation and 104Ds are coming, of having those named supervisors continuing through interacting with Msha, whether it be the rest of the inspection or the closing conferences. Consider having another foreman or another superintendent or another manager of some kind come in and be the new liaison. Because if you're the named person, you're already kind of being the one pointed at as having this knowledge or knowingly allowing that to have occurred. So anything you're saying moving forward, it's going to be recorded, and it's going to be put in the notes, and it's probably going to be angled towards supporting the allegation and helping to build that case on a special. So you should have multiple people trained to accompany Msha, if for no other reason than, people go on vacation when Msha shows up or something of that nature. It's this, because you want to be able to remove maybe someone who is getting eyed up. Again, make sure everyone's aware of their rights. Let them know Msha is going to be it's not advance notice to say there's a special investigation and we had to give your contact information to Msha. They might be calling you. We don't know if they're calling you, but we had to provide them your contact information. That's not advance notice. And, I think this one, and don't wait to engage with in-house counsel, outside legal counsel until the penalties are assessed. Especially if you're an agent management, you should have representation throughout this process. You shouldn't be sitting down for interviews without an attorney present, because again, there is liability there. Liability for both you and the company in times, but if we're in a special investigation, that liability is pointing at you as an individual. So, consider that. If you have in-house counsel, reach out to them. If you are using outside counsel, reach out to them. You just need to be working with someone going through an investigation. I think overall, and this is kind of our takeaways for the day, we talked about it before on the discrimination and on all of this. We need to train management employees on discrimination and on their interference provisions, make sure they know how to properly coordinate with legal and HR, make sure they know how to respond, make sure they have that kind of play sheet that says, I contact these people in this situation, so they're not floundering when they get in. Make sure they know that if MSHA sends you something talking about a discrimination claim, you can't just put it back in the inbox or file it away or trash it and say, oh, okay, well, I guess MSHA is going to show up at some point. You need to start acting at that point in time. As I mentioned, have something in place that outlines how we're going to respond to complaints internally as an organization, and then ensure minors, again, I keep saying it, make sure they know their rights during the investigations, because that's incredibly important. You want everyone to be well aware of what they can and cannot do. And you don't want any instance where MSHA believes that you're trying to persuade them one way or another from not cooperating or cooperating. Know that special investigations are very different than regular inspections or accident investigations even, and they must be treated and approached differently. And that's because, especially when we're dealing with special investigations, we're looking at specific agents of management. If we're looking at it from the discrimination, we're looking at a very serious claim that could possibly be drawn out for a couple of years. You could have temporary reinstatement. That could also lead to the special investigation. So there's a good bit different about these than a normal investigation. The inspectors or the investigators are much more highly trained. They know how to extract the information they're wanting, or at least how to try and get to the root issue or the root conclusion that they're seeking. So, look at that and try and consider that they are different. Understand that anything MSHA says, or anything said to MSHA, I should say, it can and it usually is recorded, probably in writing, not a recording device. But, if, as I said before, if you've seen inspector's notes, and especially if you look at one from one of the inspections that you were on, it's somewhat eye-opening to see what, when I go through those with clients, say, did you actually say this? And they're like, oh my gosh, I never said that. So, be careful with what you're saying. Know that something muttered, in sarcasm isn't always recorded that way and taken that way in the course of these investigations. So, be guided by that and be cautious about what you're saying. And then contact counsel, contact senior management, in-house, outside counsel for support as soon as you get any wind of these investigations, 105 or 110, to begin to facilitate the response for the company and for yourself. So those are really the big takeaways as we move through. So, with that, that rounds up what we're going to be looking at today. Check out the blog. We'll continue to post relevant information on there. Our next webinar is going to be on June 16th. So hopefully you'll join us then. It's going to be a bit of what to expect under the Department of Labor under the Biden administration, a bit of reading of the tea leaves, so to speak, from what we've known so far. We'll see what might come out. So far the administration, the DOL, has been very, very focused on an OSHA ETS on COVID. We might have some more insight by that point about where we're at with that, if one's going to come out, and that could ultimately impact MSHA's decision to either remain with guidance alone or bring an ETS in. So, lastly, as always, if you do have any question that you don't want to share on the chat, feel free to reach out to me directly. But I appreciate you all joining today. Thanks for joining, and everyone have a good afternoon.